Good afternoon, everyone. Thank you so much for joining. I'm Abigail Adkins. I'm a staff attorney at Southern Minnesota Regional Legal Services. I'm part of the Education Law Advocacy Project, where we work to help children succeed in schools. This is the second and last of our summer back to school series. This presentation is going to be called Building Better IEPs for Students with Developmental Disabilities. I'm giving this presentation today in English, but if you are interested in seeing the same content in Spanish, we do have a Spanish language presentation that's going to be uploaded to the Education Law Advocacy Project's YouTube page. And that Spanish presentation is presented by our colleague, Ruben Chapa. And of course, we have to give big thanks to our sponsor, the Minnesota Governor's Council for Developmental Disabilities, a statewide council that provides assistance, resources, and programming for folks with developmental disabilities and their supporters. So what do we do at SMERL, Southern Minnesota Regional Legal Services? We're the oldest legal aid program in Minnesota, and we serve 33 counties in Metro and Southern Minnesota. We help folks who reside within those counties and have a low income that's 200% of the federal poverty guidelines, although there are various programs and assets limitations which can affect eligibility. SMERLS works in a wide range of civil legal aid, including family law, housing, public benefits, and I do education law. So what do we do here at the Education Law Advocacy Project, also known as ELAP? Well, we've been a part of SMERL since 1995, and we solely focus on helping families with low income enforce their educational legal rights. What does that mean? How does that look? We use a collaborative approach to legal representation, meaning we don't just see ourselves as attorneys, but we try to build long-term relationships between families, community members, and schools. And then we work to ensure that students receive the services they need, and that after our representation ends, the families feel empowered to support their students in school. So what does that look like? We can help students and families first by obtaining equal access to educational opportunities. Second, by addressing the barriers that impede a child's ability to learn and receive appropriate educational services. And three, and again, this is one of the most important parts, empowering parents and families and getting them involved in their children's education. We work on most things that happen in, around, and going to and from school. What does that look like? Our case priorities include special education services, reading below grade level, discrimination based on disability, race, or other protected status, the education of English language learners, bullying and harassment in school, early learning, access to more challenging curriculums to prepare students for higher education, and expulsions, suspensions, and reduced school days based on disciplinary actions by the school. So if you were to call SMERLS, go through the intake process, and have your case accepted, then what happens? Well, an attorney from SMERLS would first begin an investigation into the facts of the case. That involves gathering releases of information, requesting records, discussing the family's goals for the student, and then we give legal advice. And if advice is sufficient, we might end our case there. However, if there are legal issues that might require more representation, then we might move on to the second stage. So what does legal representation look like in an education case? Well, we do negotiations with school district attorneys and staff. We attend IEP meetings, expulsion hearings at the school. We can conduct mediations at the request of the school district or client. And it's important to note that not every education case looks the same. And so different cases require different types of representation. And most of the time, with our collaborative approach, we are able to resolve school issues at this less formal level of negotiation and collaboration with the school. However, we are also able to take on dispute resolution cases that might involve filing a complaint to a relevant agency like the Minnesota Department of Education, Minnesota Department of Human Rights, the Federal Office of Civil Rights, and we're also able to represent clients at administrative hearings or in court cases. Well, so now that we've kind of done the introduction, let's look at the topics that we're going to be talking through today. So first, we're going to go over just some important terminology. I imagine that if you are here at this presentation, you might have a little bit of familiarity with special education topics and IEPs, but we're going to just do a quick recap of some important terminology. Then I want to talk a little bit about why this presentation, we're giving this presentation. Why is it important that we are building better IEPs? Then we're going to just go through IEP building blocks. So we're going to talk about the evaluations, the goals, services, and placement. And we're going to look at each of those areas individually and how they contribute to a strong IEP plan. And then we're going to talk a little bit more about just building the IEP as a team, because it is not a school only, parent only process. It has to be collaborative, and we're going to look at who is a part of that IEP team, the importance of notice and consent and parental involvement, and then we're going to talk a little bit about conflict resolution. I'm going to also try to leave some time at the end for questions. So feel free to pop your questions in the chat as we go, and then we can talk through them. Okay, so starting first with these important terms, the big one, of course, is going to be the Individuals with Disabilities Education Act, sometimes called the IDEA or IDEA. And this is the federal law that protects students with disabilities, and it requires that public schools identify, evaluate, and provide eligible students who have disabilities with what's called a free, appropriate public education. Sometimes you might hear free, appropriate public education shortened to FAPE, but essentially that means that special education services need to be provided for students who have disabilities and who are eligible under the IDEA. The next term that we're going to be using a lot is Individual Education Plan or IEP. This is going to be that document that gets created, and it should describe the special education needs, goals, and services for a student based on their disability. Now, the Individual Education Plan only falls under the IDEA, and the IEP has to be developed by the parent and the school IEP team, and it should be updated annually. I'm also going to talk briefly about what's called a Section 504 plan. The 504 plan refers to a law called Section 504 of the Rehabilitation Act. This law is also paired regularly with the federal law called the Americans with Disabilities Acts, or ADA. And but in the school setting, you'll hear it referred to as Section 504 or perhaps a 504 plan. And so Section 504 is a federal law that requires that public schools provide what's called access and accommodation for students with disabilities. And we're going to talk a little bit about the differences between a 504 plan and an IEP, but just keep in mind that a 504 plan is not the same as an IEP. It falls under a different set of laws, and it has a different set of requirements. Okay, so first let's just ground ourselves in the reason why we're talking about this in the first place, why building better IEPs is important. So we know that legally the school is required to provide the IEP. The school must provide an IEP that is designed to help the child make appropriate progress based on their circumstances. And for folks who are familiar with the the progress of disability rights in this country, you'll know that before the IDEA and before the ADA, there was a lot of segregation of people with disabilities from public services. They were not made available. And oftentimes, students who had disabilities were not being provided a full education because there was this feeling that they wouldn't really benefit from it or that it wasn't important. So whenever we're talking about improving the IEP, we're talking about making the law live up to its highest ideals, because the law requires that students receive a free and appropriate public education. And that is just the beginning, right? So we can use the IEP to make the best possible program for the student to meet their individual needs. So when we're talking specifically about kids with developmental disabilities, developmental disabilities is a kind of an umbrella term. And kids with developmental disabilities have very complex needs that can differ from child to child, even if they have the same diagnosis. A developmental disability impacts multiple areas of life, including the physical, learning, language, behavior, and these are usually lifelong conditions. Some common developmental disabilities include ADHD, attention deficit and hyperactivity disorder, autism spectrum disorder, cerebral palsy, and many more. And the IEP is a document that can show the long-term progress of a child kind of during these very formative developmental years when they're in school. And it is important because, you know, this is the time in which students really have the opportunity to receive individualized and targeted services to help them reach, you know, their full academic potential. And it's a document that will, you know, can help them later on in life when they are looking at higher education or looking at employment opportunities or looking at what types of supports they'll need as adults. So the IEP should have updated goals and services every year and updated evaluations at least every 3 years. And the IEP should also be updated as the child advances in age. There should be transition goals and services as a child gets closer to adulthood to help them with that transition. Okay, so next let's talk through these building blocks of the IEP. What are the different sections in the document? What do they mean? How do we make improvements? So we're going to talk first about the kind of the basis, the foundation of your IEP, which is the evaluation. So under the IDEA, there is a legal term that you might hear called child find. What does that mean? It simply means that schools have a responsibility to do evaluations when they have a reason to believe that a child might have a disability or if the parent requests an evaluation, right? So this is a very this can be a big area of conflict, which is when does the school need to do an evaluation? And sometimes schools will say, well, we don't think it's, you know, we think we should wait and see, or, well, you know, your child's really young, they might catch up. But And those are all fair reasons for the school to say, maybe we don't think that a disability is needed. However, there are two circumstances in which the school must do the evaluation, which is when they think that an evaluation is needed, or if the parent asks for an evaluation. So even if the school has some hesitancies, which may or may not be based on, kind of reasonable, you know, facts or, things that they've observed, if the parent makes the request, then the school either needs to give a kind of formal denial, or they need to move forward with the evaluation. So that's the first part, which is starting the evaluation. And then the next part, which is foundational to having a good IEP, which is evaluating in all suspected areas of disability. That includes academics, speech and language, social, emotional, and behavioral, physical needs, intellect and functioning skills. And the reason why, in particular, this is important for kids with a developmental disability is because we know that the developmental disability is going to impact them in multiple areas. And that those areas might shift and change as the child grows up. And either they continue to meet certain developmental milestones, or perhaps they begin to show deficits, or perhaps they, for other reasons, their condition presents different symptoms. So this is the second area where I really recommend that folks advocate strongly for their students, which is to look at all of those suspected areas. For example, a really common thing that might happen is that you have a child with ADHD, and perhaps the way that it shows up in an elementary school setting is primarily related to their behavior. They wiggle, they get up out of their seat, they make disruptions. However, it's important to look beyond sort of those perhaps obvious symptoms and not stop at an evaluation that only looks at behavior interventions, but to instead make sure, like, well, is the child reading on grade level? Are there processing speed issues? Are there receptive language issues that can also go along with ADHD? And so if a parent has a concern, if there's a doctor note that presents a concern, it's always good to ask the school to evaluate in all of the areas, not just the ones that might be the most obvious in the school setting. Okay, so what should the parent or advocate ask for when asking for that special education evaluation? This is one of those areas where the parent should be given the benefit of the doubt. If you say, I think my kid needs help, or, I feel like there's something, that, my child would benefit from in addition to what they're getting right now. However, it's very easy for requests like that to get lost in the shuffle. And so we recommend that the parents ask specifically for an evaluation for special education services. Because if you ask a more general question, the school might not do the full evaluation that is required under the IDEA to lead to special education services. So make a specific request for special education services. That request should say why the parent is concerned. So, our pediatrician says that my child's not meeting developmental milestones, or, I'm concerned because at home my child is not able to, read words with certain sounds, or, whatever the reason is. So request it for special education, use those words, special education, then include the concern, why the child needs an evaluation. And it doesn't need to be a written request, but that is the best practice because you want to be able to go back and say, like, hey, I made the request on this date. The school needs to respond in a timely fashion, right? So again, once you make the request, the school has two options for how to respond. They either need to agree to do the evaluation, or they need to, say we don't agree, and they need to give what is called a prior written notice. We're going to talk a lot more about prior written notices further on. And so these are two key things to keep in mind. And it comes up all the time, unfortunately. Schools do not have to take a wait and see approach before evaluating. Like I said, sometimes schools will say, like, well, maybe let's try some interventions that are a little bit short of a special education evaluation first. And that's fine if the school is doing the evaluation of their own initiative, meaning the parent has not made a request. But if the parent has made a request, the school must respond in a timely manner, either agreeing or disagreeing to do that evaluation. And it's also important to know that you do not have to try a Section 504 plan first before evaluating for special education. Sometimes a 504 plan can be used kind of as like a bridge while the evaluation is being completed, but you do not have to try the 504 plan first, see if it works before trying an IEP. Okay, so we're going to just dig in a little bit deeper to this idea of schools must evaluate all suspected areas of disability. There is an example here of what a evaluation notice might look like. And you can see there's one column that says, the area, and below it is listed things like physical status, sensory status, intellectual functioning, academic performance, right? Those are the kind of broad categories of the evaluation. And then there's the second column that says evals and assessments, and it lists specifically what types of tests and observations will be conducted for each of those areas. And then the third column says evaluators, and it lists who on the IEP's school team will be completing that assessment. Now, schools have the ability to choose specifically which evaluation they think is appropriate for the area. So a school can say, like, we are going to do a test called the Woodcock-Johnson test for achievement, right? That's the special education test that our district has paid for and that we use to assess students. And that's fine. However, the parent might not be able to say, well, I don't like the Woodcock-Johnson, I want you to use something else. The parent can't say that. But what the parent can say is, can you explain to me what the Woodcock-Johnson shows, and is it going to be the test that addresses my concern of this, right? So perhaps the Woodcock-Johnson basic test is not going to be sufficient, and we might need a different add-on test to look at a specific area of need. So parent and school need to jointly decide which evaluations will be done. The parent doesn't have the right to pick a specific type of evaluation, but you can request that the school explain to you why they believe that the evaluation they picked looks at the area of disability in which you have a concern. Before any initial evaluations can take place, the parent must sign consents. This is a common drop-off point where people might ask for help. The school says, all right, well, we'll do these evaluations. But then if the parent doesn't sign for consent, the evaluation is never going to get done. So make sure that after you've made the request and you've gone through all the trouble of determining what types of evaluations, that you are sure that you have signed consent for the evaluations to begin. All right, so a big question when it comes to folks requesting special education evaluation is the difference between a medical diagnosis and a special education evaluation. Um, so you might be familiar with the term like, okay, well, you're comparing apples and oranges, meaning you're comparing two things that are very different from each other, and it's not really a useful comparison. The medical diagnosis and the special ed evaluation are not like apples and oranges. They're more like oranges and then like those little like cuties or halo tangerines that you can peel. They're both citrus, but they have different shapes, different tastes, different purposes, right? So um, the flavors might be similar, but the fruit themselves are different. This is perhaps a a metaphor that only works for me, but when we're thinking about a medical diagnosis and a special education evaluation, there are some key differences. First of all, the evaluation is done by a doctor or a healthcare professional versus by licensed school staff. A medical diagnosis is going to be based perhaps on a physical exam or symptoms. The special education evaluation is going to look much more narrowly at the child's needs when they are in a school setting. A medical diagnosis will look at medications, therapies, different types of treatments, um, whereas the special education evaluation is going to look, how do we help this child either meet the kind of grade level expectations or kind of what's expected of students of their age who don't have disabilities. And this is the most important difference between a medical diagnosis and a special education evaluation, and that is that the medical diagnosis might not match up with IDEA eligibility. There are very narrow categories of eligibility for the IDEA for special education, and there are many more medical diagnoses that can lead to, very real um, deficits and disabilities. However, the school evaluation has to follow the legal requirements under the IDEA to determine eligibility. The school has to then figure out what IEP services. So does that mean the medical diagnosis doesn't matter, like the school can completely ignore it? No, the school must review and consider any private evaluations or medical diagnoses that the parent provides. Um, the parent has to give it to them or give the school permission to request the records. If the parent does not want to share those medical records, the school doesn't have any right to them. However, if the parent says, look, this is what the doctor says, and we need you to take a look at it, the school does have to at least consider it. Now, does that mean that the school has to accept the medical diagnosis or the doctor's recommendations for treatment? No, but the school does need to consider it and give a explanation for why they don't agree. And that is why it is important to share those medical diagnoses and to also make sure that your doctor writes any notes or recommendations in a way that is kind of shaped for the purpose of being used in a school setting. All right, so how do you do that? How do you use medical records to show education needs? You want to start with what you're having your medical provider include in the record. So these are the questions that you're going to want to ask your child's provider. How does this condition impact my child's ability to concentrate, their ability to learn and remember information, their ability to communicate with others, their ability to participate in school activities, and their ability to follow directions and control their behavior, right? So you want the school or the medical provider not to just say like, oh, this is how this condition might impact daily life. You want it to be very specific to the school setting, right? If you're going to share the records with the school, tell your child's provider like, hey, we'd like to get something that can go to the school. Can you make sure to address these areas? And then what records and information do you want to make sure that is included when you talk to the school? Any symptoms that are caused by the child's disability, whether those are behavioral, whether those are physical, things like fatigue, exhaustion, seizures, and what those seizures might look like, any symptoms that might appear throughout the day, and then specifically how the condition impacts the child at school, and then, of course, medications and potential side effects. So the reason why you want to ask these questions is, again, because the IDEA has limited categories of eligibility, and they are umbrella categories that developmental disabilities might fall under. However, it's important to remember that the medical diagnosis doesn't always have a direct correlation to an eligibility category. So under the IDEA, the eligibility categories are severely and multiply impaired. So that's for children who might have multiple disabilities and which cause, a kind of high level of impairment. Autism spectrum disorders, blind and visually impaired, deaf and hard of hearing, developmental and cognitive disabilities. And now that one might sound similar to a kind of medical umbrella term of developmental disabilities, but a child may or may not fit under that category specifically. There are developmental delays. That's for children who are between the ages of 3 and 7, where, excuse me, it's clear that they are behind on meeting their developmental milestones, but they don't yet have a formal diagnosis. So usually they will be placed under a developmental delay category for special education purposes until they reach about first grade. There's also emotional or behavioral disorders, other health disabilities, physically impaired, specific learning disabilities, speech or language impairments, and traumatic brain injury. So once you have gotten your evaluation, everybody needs to come together to review the results. Parents and school should meet. That can be in person, or it can be, sometimes they do them over the phone. But the important thing to know is that you're supposed to determine whether or not the student qualifies for special education. And then if not, what else can be done? Can the student be given accommodations through a Section 504 plan? Or does the parent object to the results and want an independent education evaluation or an IEE? Right? So, for example, if you feel that the school did not really consider all of the areas of disability and you would like a second opinion, you can request an independent education evaluation, and that is provided for free. It's paid for by the district. Now, if you've reviewed the evaluation results and found that the child does qualify for special education, then the team needs to determine the primary area of disability. That's going to be one of those categories that we just went through on the last slide, and whether or not there is a secondary area that should also be considered. This is an important piece, that secondary area, because sometimes you'll have a child who perhaps their most prominent school-related kind of concern is behavior, and so they might be placed under the emotional and behavioral disability category. But if there's something else that needs to be addressed, like perhaps a specific learning disability, there's no reason why that category should not also be added to the IEP. And just like with consent to the initiation of the evaluation, parents must consent to the initiation of special education services after the evaluation has been completed and the parents and school develop the IEP and goals. The parents have to sign consent again, or the IEP will not go into effect. Okay, so different school districts might use different formats for their individual education plan. However, the parts of the individual education plan are going to be similar because they're based on what's required under the IDEA. So when we look at the beginning kind of form of the IEP, you're going to see the child, their name, their grade. You're going to see, the area of disability, whether that's autism spectrum disorder, developmental delay, any secondary qualification areas. And then you're going to jump into goals. Now, a goal has its own sort of subparts. And I like to think of them as steps. The first step is going to be the domain or area of learning. That is going to be what is the goal addressing? Academics, speech and language, emotional behavioral, independent functioning. Those are the typical goal domains. Sometimes you might see slightly different wording, but the broad area that the goal falls under is going to be the domain. And then you'll have what's called the annual goal. That is the skill that the student is supposed to learn for the year that the IEP is in effect. So an IEP annual goal needs to be specific to that child. It needs to be based on their present levels of achievement. It needs to be specific and appropriately challenging, and it should not be the same goal every year. Or it should very rarely be the same goal every year, and there should be some explanation of why it's the same goal. And then underneath the annual goal, you're going to see what's called a benchmark. The benchmark is the steps which the student and the special education team are going to take in order to meet their annual goal. And this is going to be more of a either progressive or time-based goal that specifies what needs to be learned, what grades or percentages of success are needed to make progress on the goal, and what support does the student need to make the goal. And it needs to be closely aligned with the annual goal. If you have a benchmark and you're like, how does this benchmark relate to the annual goal? Then you know that, you've gone wrong somewhere and you need to kind of take a step back and make sure like, all right, does the benchmark actually help us meet the annual goal? And then the last step of a goal under an IEP plan is something that I find is often missed. And it is so important, and that is progress monitoring. Is the plan working? Does the benchmark help us meet the goal? Are we on track to meet the goal? How do we know? What data and records are going to be reviewed by the IEP team? And how often will the school send progress reports to the parents? Sometimes the school say, oh, well, progress reports come out for every child at the end of the quarter. But if that is not as often as the child needs to monitor their progress, you can always adapt it to the child. I've seen IEPs where progress monitoring is done weekly through a shared Google Doc between the school and the family. I've seen IEPs where progress reporting is done monthly through a behavior checklist. It does not only have to be kind of on a quarterly or semi-annual basis when the report cards come out. Okay, so now we're going to talk about taking your IEP goal from basic to better. So there are a lot of ways to write an IEP. Some people are, some schools and some teachers are more detail oriented and more specific in writing the IEP, but you can always improve how that IEP is written. So a basic IEP might just say like, okay, the domain is academics. The student will improve reading skills over the course of the year. That's the annual goal. Benchmarks, students will score 75% or better on reading comprehension tests. Students will be able to write a 5-paragraph essay. For progress monitoring, the teacher is going to review classwork and test scores, and we're going to send out progress reports every quarter. Right? This is not bad, right? It meets the requirements under the IDEA, but we can do better. We can work together as a team and make a better IEP. So here's an example of a better IEP goal. Domain academics, annual goal. Student is currently reading below grade level. She will increase her reading comprehension and writing skills through targeted special education reading interventions, right? So we're saying where she's at currently, what's her present levels of functioning, and we know she's below grade level. We have a goal that is appropriately challenging. She's going to increase reading comprehension and writing skills. And we have how we're going to do it through targeted special education and reading interventions. The benchmarks, those are going to be the steps to meet that annual goal. We're going to say, break it down by quarter. Student's going to score 50% or better on reading comprehension. Second quarter, 60%. Third, 65. Fourth, 75. Right, so that is the time frame and rate of progress that we're looking for. And then we're going to go further than that. We're going to explain how and what we're looking for. When provided with grade level text, a graphic organizer, and extra time, a student will write a 5-paragraph essay that identifies the who, what, where, when, why, and main point of a reading passage. How will we do progress monitoring? The teacher is going to review classwork, student writing, online reading assessments, and test scores. Progress reports will be sent every quarter, and the parent can review weekly progress of online assessments on the student portal. Why do we need to take this IEP from basic to better? It's because when you have a plan, you know where the plan goes wrong, you know where the plan succeeds, and you can make adjustments as needed. If you don't have that good plan, you really won't know until the end of the school year whether or not the child has met that goal. All right, the next IEP block is going to be services. So under the IDEA, there are 2 main categories of services. There are related services and supplementary services. The reason, the best way to keep these separate in your mind is that a related service is what the child needs from special education. These are the services that will help them benefit from their specialized education. So those are special education instruction, transportation and mobility, counseling and social work, medical and nursing services, physical, speech, occupational therapies, or adaptive physical education. On the other hand, a supplementary service is the support that the child needs to participate in the general education setting. So when they're in a classroom with their non-disabled peers, what kind of supports do they need? That could be paraprofessional support, assistive technology, sensory and calming support, student breaks, shortened assignments, testing accommodations, or teacher training. The next building block is placements. And it relates very closely to those services we talked about on the last page. And that's time spent in special education or general education. Placement refers to kind of different levels of time spent with non-disabled peers. There are 4 levels here in Minnesota. Students have the right to be educated in the the least restrictive environment. And that means that they should spend the maximum amount of time appropriate in a general education setting. And the IEP team needs to consider what services will help the student participate in general education. The important thing to remember is that placement comes only after the IEP has been developed. You have to know what the goals are and what we're going to do to meet those goals and what services are needed to meet those goals before we can even talk about what school has the services necessary. Placement has to be determined annually based on the IEP, and generally a placement is appropriate if the facility or school can provide all of the education, services, and supplementary aids that are listed in that IEP. Now, here is an important caveat. Districts don't have to offer every service at every school, just based on practical, financial, organizational reasons. However, the school does need to meet the needs that are listed in the IEP. All right, so we're going to talk briefly about building the IEP as a team. Who is a part of the IEP team? Parents, special education case managers, the special education teachers, paraprofessionals, school psychologists or therapists, general education teachers, school district or district administrators, outside therapists or providers that the parents have asked to be a part and who have relevant information about the child, and then any advocates or attorneys who've been invited by the parent. How do you, as a parent or advocate, prepare for an IEP meeting? Before the IEP, you want to make sure that you've scheduled it at a time and place that you can attend, in person, over the phone, virtual, whatever works for you. If you need language interpretation, especially because sometimes educational documents can be very technical, you can ask the school to provide interpretation, and that has to be provided for free. And you should also just let the school know if you're going to be inviting any advocates or other supportive individuals. What do you bring to your IEP meeting? Any important medical records, those supportive individuals, any notes about how the child has been doing at home, and a list of concerns that you want to discuss at the meeting. So now you're there, you're sitting around the table, either in person or virtually. What should you ask at that IEP? So first, those questions about the IEP itself. Is my child on track to meet their IEP goals? How does my child compare to grade level standards? What are the special education services provided? Essentially, is what's written in the IEP actually being done? And are the services that are being provided, do they happen in the general education classroom through those supplementary aids and services that we talked about, or are they in a special education setting? That's something that would relate to the placement. You want to make sure that you're addressing any concerns related to behavior and functioning. Are there certain situations or environments that are challenging for my child? How does my child respond to the support services in the IEP? Do they actually like having a paraprofessional, or does it make them feel embarrassed and they want to work more independently? How does my child do with other kids in the classroom? Are they able to make appropriate kind of relationships and friendships in the classroom? Are they participating? And then you want to make sure to follow up on any questions about what you can do at home to help, who you can contact at school if you have concerns, and then make sure to schedule that next IEP team meeting. Get that on the calendar while you're all there. Then after the IEP, the work is not done. It always continues. You want to make sure that you are addressing notice and consent. And that is going to be through a document called a prior written notice that has to be provided by the school. The prior written notice, or PWN, has to explain what the IEP team discussed, what the school is proposing to do or change, if the school does not agree with something requested by the parent and why they don't agree. And then the PWN has to ask the parent for consent to move forward. If the parent agrees with the school's proposal, if the parent disagrees with the school proposal and wants to have another meeting or conciliation conference. And then the parent must sign and return the PWN within 14 days, or the school is going to move forward with its plan. So in the earlier stages of the evaluation and initial IEP, the school can't move forward unless it gets that consent. Once you've gotten past that to the IEP itself, any updates or changes, the PWN has to be signed and returned within 14 days, or else whatever the school has decided is what's going to happen. So let's talk through some common disagreements about the IEP. What services are needed? If the child needs a paraprofessional at school, how much time should the child spend in general education versus special education? How to handle student behavior? What school location can provide the needed services? What type of special education transportation is needed? These are the things that happen all the time. And it's, important to know that an IEP and special education is an ongoing process. It is collaborative between the school and the parent. And so when you're handling these disagreements, you want to keep in mind that this is a long-term relationship. So make things in writing so that there's a paper trail, and keep a copy for yourself and your records. Carefully read your prior written notice before signing. You do not have to sign a prior written notice if it's incorrect. You can send it back in writing and say like, hey, I don't agree with this part, or hey, I think you left out this part of our conversation. Would you update the PWN before I sign it? That is perfectly allowed. Or you can just say, I object to this prior written notice. I'd like to have another meeting. So these are, children that we're talking about. It is very understandable to have a strong emotional reaction to the needs of your child and how they're being treated at school. And that can happen on both sides, the family side and the school side, who, often also care about the child very much and, might have just, reasonable disagreements about what's best in the school setting. So whenever possible, take a break before responding if you're feeling upset or overwhelmed. It can help you, one, just process how you're feeling in the moment, and then two, give yourself time to figure out how you want to structure your next step. And then if there are disagreements that you just can't get around, you can always contact advocates or attorneys about your children's legal rights. So there are several formal dispute resolution options. We're going to just touch on those briefly. There's what's called a conciliation conference. That is similar to a mediation, but there's no third-party mediator. The parent and the school are going to meet. It has to be held within 10 days of the request, and afterwards, the school must write a final proposal of service within 5 days. Then there's what's called a facilitated IEP team meeting. This is not required under the IDEA, but many school districts offer them upon request. And essentially, you're asking for a trained professional from the district, from the State Department of Education to come in and facilitate their IEP. Parents and schools have to agree and fill out a request form to the Minnesota Department of Education. And the state then provides this neutral facilitator. These can sometimes take a little bit longer to schedule, about 3 weeks. And so then for dispute resolution options, that includes mediation. Under the IDEA, mediation for special education related incidents for kids who are in early intervention services under 3 years of age, the mediation has to take place within 30 calendar days. There is more wiggle room for scheduling if the child is older than 3, but in any rate, the parent has to fill out a request for mediation. There's a form available through the Minnesota Department of Education. Usually takes about 3 weeks for mediations to be scheduled. And a mediation is more formal. You have a third party neutral mediator who is then going to help both sides talk through the disagreement and come to perhaps some type of compromise. And then there's the more formal legal options to bring issues for resolution. There is a special education complaint. That is a complaint that is written to the Minnesota Department of Education requesting that they investigate to determine whether or not the school district has denied the child with what is legally required under the IDEA. That's that free and appropriate public education that we talked about at the very beginning, also called FAPE. And in most cases, MDE is able to resolve that issue within about 60 days, although lately there have been some delays. So it is not always able to be done quickly. Then there is a even more formal way of resolving disputes, and that is what's called a due process hearing. That is a more formal court complaint that goes to an administrative law judge who will then schedule a hearing, the sharing of evidence under kind of legal rules. Parents can represent themselves in due process hearings. However, it is usually recommended to at least consult with an attorney before moving forward with a due process hearing. The administrative law judge will then issue a decision within 45 days, and that final decision may be appealed to a higher court. So if you have any questions about how to fit where you are at in your IEP process with the whole, with kind of the whole set of steps, we have a hopefully helpful flow chart for you that walks you through identification and referral, an initial evaluation, reviewing that evaluation and determining eligibility, and then deciding whether or not the child qualifies, if an IEP is appropriate, or perhaps a 504 plan, and then implementing the IEP, monitoring progress, and reevaluation. Take a look at this flowchart and see if it helps you clarify where you are at in the IEP building process. All right, we're going to pause for questions and comments.
Thank you, Abby. So we've got a couple questions in the chat. And so our folks had to hop off, but maybe we can just answer them on the recording and then people can take a review. So the first question / comment is, we have a lot of schools around us that don't do any updated evaluations every 3 years and instead do a review. What are some ways I can hold them more accountable?
So a review is allowed, and it's always a good way to start the evaluation. However, that should not be the end all be all. You can always just ask the school to conduct an updated evaluation. You can say, based on this child's age, we think that it's appropriate to redo this evaluation. Or, based on new symptoms, we would like to get an updated evaluation. And the school can try and come up with a reason for why only a review is appropriate, but they're going to have to be the ones to explain why they believe that in their prior written notice. And then once you have that prior written notice, you can object to it. and say, if the school isn't willing to actually update the assessments that were last done 3 years ago, then we're going to request an independent evaluation. And usually at that point, the school will be willing to do the assessments themselves, because if it's a cost related matter, getting the school to conduct the assessment is going to be less expensive than the school paying for a private evaluation. Yeah, that's a great question.
Okay, thank you. And then our last question is, I've had a school state that their school policy is to do interventions for X amount of weeks before doing an evaluation. How can I hold them accountable when legally that's not correct?
So this is a common misunderstanding between schools. And it usually shows up where children have what's called a specific learning disability. There is a portion of state and federal law that says that the school should conduct a certain amount of interventions in order to determine whether or not that um, child does have a specific learning disability. However, that applies to when the school is initiating the evaluation. It does not apply to when the parent is making that request. There is a specific provision in Minnesota statutes that allows parents to waive that intervention period and say, I'm requesting that you move forward with the evaluation now. Now, that doesn't mean that interventions aren't helpful data. They can certainly continue alongside of the assessment, but they don't need to delay the assessment or IEP evaluation from beginning. Also a great question. And if anyone would like to consult with us directly, feel free to contact ELAP. Our website has online resources. We have a newsletter, social media, and you can also contact our general email, or feel free to contact us directly with any questions or concerns. We're more than happy to help or see if you qualify for services through SMERLS and ELAP.
Thank you.
All right, thanks.